Well, our final panel today has the title Immigration, Citizenship, and the Trump Administration. I'll introduce our three panelists, and then the format will be much like the others, 10 minutes each. We'll have a little crosstalk, time for questions, and then John Eastman will have some closing remarks. Since I've introduced John twice now today in different forms, I'll just say he's great, you know him well, look forward to it. Yeah. After John, we'll have Edward J. Erler. He's professor of political science emeritus at California State University, San Bernardino, where he taught courses in political philosophy, American government, and constitutional law. Dr. Erler is also a senior fellow of the Claremont Institute and a member of our board of directors. He's the author of The American Polity, Essays on the Theory and Practice of Constitutional Government, and co-author of an important book I encourage you all to look up, The Founders on Citizenship and Immigration. And he's just finishing up an important book on the political philosophy of the American founding. We'll let you all know about that when it's ready. Finally, we have Hans Spakovsky, who is a senior legal fellow in the Heritage Foundation's Edwin Meese III Center for Legal and Judicial Studies, and he's manager of Heritage's Election Law Reform Initiative. Hans is an authority on a wide range of issues, including civil rights, civil justice, the First Amendment, immigration, the rule of law, and government reform. And you've probably seen him often of late sharing his wisdom with the assembled audiences on Fox News and elsewhere. So please join me in welcoming my panel. John Eastman first.
So I left my notes for this part of the panel back at home, so let's see if I can do this flying solo.
You want to use mine?
I'm going to try and tie some of this stuff together, both the Trump administration executive orders and the Obama administration executive orders, the notion of executive power here, but also the notion of citizenship and sovereignty, because they all seem to be tied up. Let me start with that last point. There is a move afoot by the left-leaning legal academy to destroy any notion of sovereignty. They've taken from our Declaration of Independence, which asserts a very fundamental human or unalienable right to emigrate. It doesn't do it in exactly those terms, but that's what's at issue. The English rule at the time was once you were a subject, you were always a subject, and you could not renounce it. And we assert in the Declaration of Independence that one people have a natural right to sever their ties and form their own government when they think it's most conducive to the ends of securing their inalienable rights. Unpacked, that's the unalienable right to emigrate, to leave your existing body politic and take up with somebody else. If that somebody else will have you, and this is the piece where the folks have gotten it confused. The right to emigrate, to leave, is not the same thing as the right to immigrate, to come in. All right, and the right to immigrate on those same principles as set out in the Declaration of Independence requires a mutual consent. I can't make all of the people in Mexico City American citizens just by saying they're American citizens, but neither can they claim American citizenship just by demanding that they should be treated as citizens. It takes both an offer and acceptance, to use our language of contract or social contract theory. The modern left legal academy says otherwise. They confuse this notion of the right to emigrate and the right to immigrate, and there is a fundamental human right not just to leave, but necessarily, if I'm going to leave, I have to have some place to land, and I don't need your consent to land in your place, and therefore there is no such thing as borders that can be controlled by the existing body politic. That's a radically different view of these questions than our own Constitution and our Declaration set out. And then the question is, if you are going to have any potential limits on immigration, where do you assign the authority to set that line? Because it's not something drawn from nature, how much or how little immigration any particular people can have without changing the nature of their regime. This is not something that we can look to Plato's Forms and figure out. It's a political question. And the question then becomes, where do I assign in this particular regime the authority to make that political question? And our Constitution is not perfectly clear on this. There's some ambiguity. Congress has the power to make a uniform rule on naturalization, But of course, naturalization is making citizens. It's not the same thing as immigration. I can have immigration without naturalization. And so some arguments have been leveled that the power of naturalization is not to actually include a power to regulate immigration. Now, there's an inference to be drawn from Article 1, Section 9, that Congress has no power to restrict the importation or migration of persons into this country until 1808. Well, why would you tell them they can't restrict it if there's not somewhere in their authority the power to regulate migration or immigration? Migration for people that were coming not of their own accord, and immigration people that are coming of their own accord. So there's inferred from that restriction a power to regulate immigration that Congress apparently has. And if it's not the power over naturalization, then maybe it's the power to regulate commerce with foreign nations, the immigration maybe, or maybe it's inherent in sovereignty. But in either of those cases, it's been long understood that the plenary power to set immigration policy is vested in Congress, not in the executive and not in the judiciary. Now, a few years ago, the Supreme Court, Justice Kennedy, got that really bollocksed up. And they were confronting a law out of Arizona where Arizona had grown tired of the executive branch in the federal government not properly or not at all enforcing the immigration policy that was actually the law on the books that has been adopted by Congress. And they said, well, we don't have to sit idly by and wait for that. We can't take immigration policy into our own hands, but we can certainly help enforce the federal laws that are on the books. And if we detain somebody who's here unlawfully, we can't send them across the border ourselves, but we can turn them over to the immigration officials. Now, if they release them anyway, there's not much we can do about that, but we can certainly help with this process. The Supreme Court said no, largely, but it did so by misunderstanding this core notion that had been long expressed in the Supreme Court, that Congress has the plenary power to set immigration policy. Every citation in the court's decision on that point puts the quotation marks differently than is the actual case. And they replace the word Congress has plenary power with the federal government has plenary power, which then means that the executive has plenary power. And if the executive chooses not to enforce the laws that are on the boards, on the books, that's the governing authority in the land. And it just perverted the notion, or turned upside down the notion, that in our system, Congress is the one that sets that basic policy. That then newfound authority, I think, sets the groundwork for President Obama's DACA and DAPA decisions, which tie into the last panel. These were not executive orders. They were not notice and comment rulemaking regulations. This was a memo from the Secretary of the Department of Homeland Security, Janet Napolitano, I'll get back to her in a minute, to line officers basically ordering them not to enforce federal immigration law as it was on the books. And they made the argument that this is just an exercise of prosecutorial discretion. We know prosecutorial discretion when we see it. I dare say if some of you came up on the highway, it was clear traffic, you might have actually gone a mile or two over the speed limit. And if you passed the highway patrol officer going only that limited amount over the speed limit, you probably didn't even break a sweat, because he's going to exercise prosecutorial discretion and not stop you. Now, if you were going 95, a different view of prosecutorial discretion would likely have played out. Prosecutorial discretion is the kind of on-the-ground judgment by the line officer on a case-by-case basis to decide whether to enforce the law fully to its ultimate extent on any given instance or not. The court has made clear that there's a line, a distinction between that kind of discretion and enforcement and a categorical suspension of the law. And has said, and it's never drawn that line for us, but it has said it exists, that at some point this exercise of the discretion ends up being an abdication of the executive's duty to take care that the laws be faithfully executed. All right? Now, what the Obama administration did with these two executive orders, DACA and DAPA, I think crosses that line, because it was a categorical suspension of the law for anybody that met criteria that they set out, criteria that do not exist in the law that's on the books. And they were therefore changing the law, overturning the plenary authority of Congress to set immigration policy and setting their own. Now, at the time, they argued, oh no, that's not what we're doing. This just sets out guidelines. Just because you meet those criteria doesn't mean you're going to get the deferred action. There was not a single individual in the country of the 6 million people that got deferred action under those two programs that met the criteria and didn't get the deferred action. The only people that didn't get deferred action are those that didn't meet the criteria. So that criteria now has become the law rather than the law. I think that means that they have categorically suspended the law as it was written and put in their own in place. The difficulty is when that question gets to the courts, where is the court going to draw the line on how much enforcement is necessary for it to cease to be a categorical suspension? And I think the reason in our 200-year history the court has never precisely drawn that line is because that's probably a non-justiciable political question. We don't know what that line would look like. We don't know what criteria would go into it. And therefore, I suspect the court would have ducked that issue by saying, we don't know where to draw that line, and we're going to just treat this as not something we can consider. Now, that was the first part of DACA and DAPA. But DACA and DAPA did two other things that were rather dramatic. They then treated those who were here on this deferred action as though they were lawfully present in the United States. Now think about it, what a dramatic difference that makes to the normal prosecutorial discretion. If you're going 65 and a 60, and you pass the police officer and he exercises his discretion not to stop you, that doesn't give you a certificate to keep going 65 down the road. It doesn't give you a lawful speeding license, a lawful presence on that highway. And yet Obama's orders, or more properly Napolitano and Jay Johnson's orders, did just that. And then derived from that lawful presence, and they're very careful to say lawful presence, not lawful status, because the statute says you can't give a lawful status. So, well, we didn't give a lawful status. We just gave a lawful presence, as if those two things aren't exactly the same. I mean, it's crazy. But then they said, now that you have a lawful presence here, you're entitled to a whole slew of benefits that are only available to people who are lawfully present in the United States, such as work authorizations. And with the work authorization, Social Security numbers and Social Security benefits, and earned income tax credits on your tax return, retroactive to 3 years for the statute of limitation. All of this transfer of federal monies without appropriation of Congress, in violation, again, of Article 1, Section 9. So that's the world we live in. The DAPA program was challenged by Texas and the Solicitor General's offices there. And it was put on hold, but not for any of those constitutional grounds. It was put on hold and joined nationwide because this massive change in policy by the executive branch had not gone through the Administrative Procedures Act requirement for notice and comment rulemaking. And so that was the narrow holding of the court, the Fifth Circuit and the District Court in that case, even though both the District Court and the Court of Appeals in that case laid out in a lot of dicta what they thought about the constitutional questions as well, leaving no doubt that the president's conduct was unconstitutional on those grounds too. So that's where we stood. DAPA was not being enforced because it was under national injunction, but the suit had not challenged DACA, which stands or falls on exactly the same terms as the DAPA program did. So it was equally illegal under the Administrative Procedures Act and quite likely unconstitutional on these other grounds. Then we get to the change of administration and President Trump. And he decides, partly because it's patently illegal under the existing precedent, to suspend DACA, or at least that's what he claims he's going to do. They actually did revoke the DACA memorandum, but they have not yet started implementing it by revoking the deferred action status. So we're kind of in a limbo there on 6 months while the Congress tries to decide what it's going to do. But last week, the same Janet Napolitano who had authored the DACA memo without going through the Administrative Procedures Act notice and comment rulemaking process, files suit against Trump with the height of chutzpah, claiming that he can't remove the DACA program because he didn't go through the Administrative Procedures Act notice and comment rulemaking. Now, you think I'm kidding about this, that no credible law firm could be so silly as to make such a frivolous argument, and yet it's one of the premier boutique law firms in the country that weighed in on behalf of Napolitano, who is now the chairman of the Board of Trustees of the University of California Higher Education System. It's rather extraordinary. The second piece, and there are only 2 counts in the lawsuit, the second component of the lawsuit is all of the people that were given deferred action have a legal entitlement to keep it. Now remember, the original program was only allowed for 2 years, and you had to then reapply to get it renewed every 2 years. The DAPA program comes in and extends that renewal period to 3 years, but it still has to be renewed for every 3 years. And at the conclusion of both of these memos, it says there are no legal entitlements that flow from this. This authority can be revoked at any time. This is what it says. But now she's saying it can never be revoked. It's not even a 2-year or a 3-year program, but if you don't keep it renewing in perpetuity, you will have undermined their reliance interest on being here lawfully present in the United States, even though we've acknowledged that there can be no such interests that flow from that. Those are the 2 points of law that are challenged in these lawsuits that were filed. The danger or the fear I have is I have no doubt, since those lawsuits were filed in the Northern District of California, which is San Francisco, where the right to appeal is the Court of Appeals from the Ninth Circuit sitting in San Francisco, that they're going to find that President Trump's repeal of the DACA program is illegal because it didn't go through the notice and comment rulemaking process, which had not been gone through when it was created in the first place. And this is an extraordinary thing on so many levels. The collaboration of the judiciary here on the West Coast with a hyper-partisan use of lawfare to block the results, the authority of this president and the results of the last election is a dangerous threat to the rule of law more broadly. And it's well beyond the context of just the immigration ruling. But that one is particularly important because, as I started at the outset, it goes to the heart of the nature of consent for the foundation of governments, the notion of sovereignty, the notion of who we are as a people, and the rule of law on who we have assigned the power to designate how much or how little immigration we're going to have at a particular time, how much immigration we think we can absorb without radically changing the nature of the political regime. These are the questions that were commonplace for the American founders, but a whole segment of our modern fellow citizens don't even seem to understand the nature of the question. Thanks very much.
Well, John has covered some of the subjects that I intended to cover, but we do have 1 or 2 slight disagreements, so we might be able to hash those out. I may say some things that you will dislike, but that may provide some room for discussion. I may even cause some dignitary harm to you, which may provide further grist for discussion. Now, perhaps some of you may remember when in May of 2016, Secretary of State Kerry advised his fellow citizens to prepare themselves for a borderless world. And I think everybody understands that a borderless world will be a world without sovereign nations, without sovereign nation states. Consequently, a world without the exclusive citizenship that attaches to separate and equal nations. And here I use the language of the Declaration of Independence. When the sovereign nation state has given way to the universal homogeneous state, citizenship will be replaced by what has been called universal personhood. This has been the goal of progressivism for more than a century. Now, I think everybody understands that, historically at least, constitutional government has been found only in the nation state, where the people share an exclusive common good and are dedicated to the same principles and purposes. The goals and principles that animate a people may be universal, as in the case of the Declaration of Independence, but the pursuit of those principles can take place only in a particular political community. The fact that all men are created equal and possess by nature the right to life, liberty, and the pursuit of happiness is a universal principle applicable to all human beings. But for that principle to become a political reality, an equal and separate nation had to be created dedicated to that proposition. Any attempt to set that principle in motion on a universal scale at the time of the founding would have failed. And it will fail today, despite the wholly untenable and fabulous claims that the rights of individual citizens have evolved into an easily recognizable universal personhood. The homogeneous world state, let us say the EU on a global scale, will not be a constitutional democracy. It will be the administration of universal personhood without the inconvenience of having to rely upon the consent of the governed. Needless to say, universal persons will not be citizens. They will be clients, or more properly, subjects. Rights will become superfluous because the welfare of the community will have superseded individual rights. Now, more than a century ago, just when the progressive dream of the world homogeneous state was beginning to emerge, the Supreme Court announced what was considered to be the settled sense of the matter when it remarked that it is an accepted maxim of international sovereignty and essential to self-preservation to forbid the entrance of foreigners within its dominions, or to admit them only in such cases and upon such conditions as it may see fit to prescribe. That was the definition of sovereignty and its relation to immigration. Immigration control was thus thought to be an indispensable aspect of sovereignty and essential to self-preservation. It is clear, however, that progressive liberalism no longer views self-preservation as a rational goal of the nation state. Rather, self-preservation must be subordinate to openness and diversity. And here's an unusual source. Pope Francis has recently voiced his agreement with this aspect of progressivism when he marked recently that the welfare of refugees and migrants should take priority over national security concerns. President Obama and Hillary Clinton, both when she was president, when she was Secretary of State and candidate for president, agreed that acceptance of Muslim refugees was an important affirmation of the country's commitment to openness and diversity. Clinton stated that acceptance of refugees was not only a reaffirmation of America's commitment to diversity, but also a reaffirmation of who we are as Americans. Clinton apparently assumed that the American character is defined only by its unlimited acceptance of diversity. A defined American character, devotion to Republican principles, Republican virtue, the habits and manners of a free citizen, self-reliance, would of course be considered as impermissibly exclusive. Most of the refugees who entered the United States and those who sought asylum during the Obama administration did not have adequate documentation, and the heads of the major security agencies warned that active terrorists and terrorist sympathizers would inevitably slip through the security screening cracks. Clear implication of Obama's policy was that America's commitment to diversity outweighed considerations of national security. President George W. Bush was also an advocate for a borderless world. He frequently stated that family values don't stop at the border. You probably remember that. He frequently stated that he was in favor of amnesty and a path to citizenship for illegal aliens, and indicated that certain universal values transcended a nation's sovereignty. Bush's compassionate conservatism was on full display here. And he said on several occasions that we should be more compassionate to our less fortunate neighbors to the south. The same kind of rhetoric was used by President Ronald Reagan when he signed the Immigration Reform and Control Act of 1986. The act provided amnesty for 3 million illegal aliens and was touted at the time by President Reagan as a way of humanely dealing with the issue of illegal immigration. In his signing statement, Reagan said the act is both generous to the alien and fair to the countless thousands of people throughout the world who seek legally to come to America. The act was supposed to be a one-time only amnesty in exchange for stronger border control. But only the most naive in Washington, and they were mostly Republicans, believed that the promise of border control would be honored. Illegal immigration continued unabated. The act, of course, also fueled expectations and even demands for additional amnesties, even that amnesties become a regular feature of American immigration policy. Delays in implementing new amnesties have been treated with contempt by immigration activists and proffered as evidence that the American people lack compassion. And here I ask you to remember Jeb Bush's statements during the 2016 presidential primaries. Now, almost any clear-thinking observer can see that compassion is not a sound basis either for foreign policy or immigration policy. Compassion is more likely to lead to contempt than gratitude in both policy areas. The failure of the 1986 amnesty should be a clear reminder of the useful Machiavellian adage that in the realpolitik world of foreign affairs, it is better to be feared than loved. Fear is more likely to engender respect, whereas love or compassion is more likely to be regarded as a contemptible sign of weakness. In 1984, Reagan had received 37% of the Hispanic vote. But after the 1986 amnesty, the vote for his successor, George H.W. Bush, declined significantly to 30%. Granted, Bush was no Reagan, but such ingratitude seemed to puzzle Republicans. It should not have. Donald Trump, in the 2016 presidential campaign, appealed to the importance of citizens and borders. In other words, Trump took his stand on the nation state and nationalism against the world homogeneous state. He reminded the nation that the just powers of government are derived from the consent of the governed. The people, therefore, are the sole source of legitimate authority under the Constitution. The President's speech to the UN earlier this week was a celebration of sovereignty and the nation state. The nation state, Trump said in a statement that was as true as it was hyperbolic, remains the best vehicle for elevating the human condition. In appealing directly to the people in the election of 2016, President Trump succeeded in defeating both political parties, the media, political professionals, pollsters, academics, and the bureaucratic class. All these groups formed part of the bipartisan cartel protecting the Washington establishment. The cartel is now quite hysterical, fighting to save the entrenched interest that it has represented for so many years. So far, it has made a remarkably good showing, but Trump has scored some notable victories, not the least of which have been in border security and immigration enforcement. The president, however, is facing a conundrum on the Deferred Action for Childhood Arrivals program. It is not a conundrum of his own making, but a result of past failures to enforce already existing immigration laws. During the presidential campaign, Trump promised to end DACA. He quoted Obama's oft-repeated lamentation that he had no constitutional authority to act on the matter. It was solely the province of Congress, Obama said. When Congress failed to perform, however, Obama did act. Ordering the Secretary of Homeland Security in 2014 to implement a program to stop deportation of children brought to the U.S. as minors. Restraining order from the Texas District Court in 2015 halted implementation of the program, as Professor Eastman mentioned. We have a difference, however, as to what the precise holding of that case was. I thought that he did reach the constitutional issue, but I'll defer to Professor Eastman on this. I thought that Judge Hannon's holding, or his principal argument, relied on separation of powers, but I could be wrong. I thought that he had ruled that the executive branch had no authority to award legal status to otherwise deportable aliens, and that he had said that this requires legislative, not executive authority. Prosecutorial discretion, which is a proper executive function, cannot be expanded to encompass a power that clearly belongs exclusively to the legislative branch. That, I believe, is a separation of powers argument. The Fifth Circuit Court of Appeals affirmed, and the decision was upheld by an evenly divided Supreme Court. Now, as Professor Eastman mentioned, Trump has rescinded DACA. Of course, the Texas District Court didn't rule directly on DACA. It was on DAPA, the Deferred Action for Parents, but all of the arguments in DAPA, as the court itself indicated, apply equally to DACA. Now, Trump, as everybody knows, has rescinded DACA, but he's delayed its rescission for 6 months, inviting Congress to pass legislation reinstituting the Obama executive action. The president hopes that Congress will comply and has even said he is willing to deal. This, of course, will cure the separation of powers difficulties identified by the courts, but there is still a question of whether a law aimed specifically at one class will satisfy the Constitution's requirement that laws regarding immigration be uniform. The president, of course, has had a constitutional duty to rescind the unconstitutional program, but it is curious that he allowed it to continue for 8 months. In fact, there has been no rescission at all. DACA has only been suspended. No new DACA applications will be accepted for 6 months, but pending applications will be processed and work permits that expire will be reauthorized. But if Trump believes DACA is unconstitutional, how can he allow such benefits to be conferred during the suspension period? And in a curious turn, the Trump Justice Department has not withdrawn the Obama Justice Department's 2014 opinion arguing the constitutionality of DACA. Trump, of course, campaigned on the promise to end DACA, saying there would be no amnesty or path to citizenship for the so-called dreamers. He said that those who came to the U.S. illegally would have to return to their home countries and apply for re-entry. These are beautiful people, Trump frequently says, and in many cases, highly educated. He does not use these words, but what he means is they deserve our compassion. If Congress is unable to agree on a bill, Trump has hinted that he will act. He has not said what he will do, but surely he cannot be contemplating revival of DACA by executive action. I do not believe the president will follow his predecessor into the netherworld of post-constitutionalism, however much he may believe that the end of DACA would demonstrate a lack of compassion. DACA has thrust the president on the horns of a dilemma, but this does not alter his obligation to uphold the Constitution. Thank you.
Don't disagree.
Huh?
We don't disagree.
Oh, okay.
Maybe on the whole thing.
I'm going to talk a little bit about the Constitution, the law, but I'm also going to talk about public policy, and I'm frankly going to talk about the deceit in the media, in their coverage of the immigration issue, and in the academic community, which probably doesn't surprise too many people. What you need to understand, and I think you all recognize, is that for the past more than 2 decades, those who advocate in favor of illegal aliens, and that, by the way, is the correct legal term. That's the term the Supreme Court uses, so I'm going to use that term. But those who advocate in favor of amnesty for illegal aliens, what they've been trying to do now for 2 decades is to extinguish the line between illegal immigrants and legal immigrants, and to basically provide that illegal aliens have all the same rights as legal immigrants. Now, there's a reason for this that you all understand. Yeah, there are some folks involved in this who think that's the right thing to do from a public policy standpoint, but what you really need to understand is that the vast majority of the people in the progressive community who are behind this are doing this for one reason and one reason only: raw political power. That's why, for example, in another area that I cover, voting, I can give you example after example after example of Democratic politicians and activists doing everything they can to make sure that states do not verify the citizenship status of individuals who are registering to vote, because they want non-citizens registering and voting, because they know the breakdown, the polling shows non-citizens favor Democrats over Republicans about 80% versus 20%. And also by extinguishing the line between illegal immigration and legal immigration, that makes it easier for them to make the false claim that if you are in favor of enforcement of our immigration laws and against illegal immigration, then you're a racist and you're anti-immigrant. Now, let me read a quote from you. And by the way, I should tell you, in the midst of all this, everyone should realize we are the most generous country in the world when it comes to legal immigration. We take in more than a million legal immigrants a year. That's more than every other country in the world and most of the countries of the world combined. So this idea that we are somehow anti-immigrant because we want to enforce our laws and bring back the rule of law, which is the base of the country, is totally absurd. Let me read you a great quote from Barbara Jordan. You remember Barbara Jordan? Barbara Jordan was a civil rights icon. She was the first African-American woman elected to the Texas legislature. She then went on to Congress, and in the 1990s, Bill Clinton put her in charge of a commission on immigration reform. And here's what she said, which I think is just great on this issue. We disagree with those who would label efforts to control immigration as being inherently anti-immigrant. It is both a right and a responsibility for a democratic society to manage immigration so it serves the national interest. Unless this country does a better job in curbing illegal immigration, we risk irreparably undermining our commitment to legal immigration. Now, you often hear the terms that we have a broken immigration system. That is not true. We have, in fact, a very comprehensive set of laws governing immigration. The problem has been that for a very long time, the political will in Washington and elsewhere was not there to enforce the law. Now, the cost to the United States of illegal immigration is enormous. You all know the numbers that are generally accepted for this is what the Department of Homeland Security has, is about 11 to 12 million illegal aliens in the country. Some people put it at a higher number. One estimate from 2011, so that's a while ago, was that those illegal aliens cost federal, state, and local governments $113 billion, of which only $29 billion is at the federal level. The rest is down at the state and local level. Now, at the federal level, it's estimated that the feds take in about a third of that amount in taxes from illegal aliens. At the local level, only about 5%. So there's a huge outlay going out. And what do those costs cover? Public education, medical costs, law enforcement, public assistance, and general other expenditures. This is an enormous amount of money. How big is it? Well, I actually found an estimate. I think in 2010, 2011, California had a budget deficit of about $14.5 billion. The costs spent on everything from public education to unreimbursed medical costs at hospitals and elsewhere of the illegal aliens in the state was over $21 billion. So if you didn't have this illegal alien population, you would not have had a budget deficit in that year. Now, a couple of years ago, the Heritage Foundation, where I work, did a very comprehensive analysis by one of the leading experts in the country on how much it would cost us, and by us I mean all of you as taxpayers, if we provided amnesty to the 11 to 12 million illegal aliens in the country. And the way they calculated that was, you all need to understand, the average educational level of an illegal alien in this country today is the 10th grade. They are low-skilled, the vast majority of them are low-skilled, low-educated. So what we did is we took a look at how much would those aliens be expected to earn in their lifetime, how much would they pay in state, local, and federal taxes, and then how much would they collect in government benefits, Social Security, Medicare, et cetera. The net cost to the American taxpayer that we came up with was $6.3 trillion. That's what amnesty would cost. And here's another quote from Barbara Jordan, and this is the effect that you never hear talked about of importing large numbers of low-educated, low-skilled illegal aliens into the country. Barbara Jordan, why have liberals been silent about the economic effects of immigration on their natural constituency, the working poor and black workers in particular? There's no national interest in continuing to import lesser skilled and unskilled workers to compete in the most vulnerable parts of our labor force. Many American workers do not have adequate job prospects. We should make their task easier to find employment, not harder. Now, you can see that the difference it makes in enforcement just in the rhetoric that comes out of the White House in Washington. Since President Trump came in and he's made these kind of pronouncements, border crossings dropped like 70% from the time he was inaugurated. Now, recently it's gone up a little bit again, but there was a huge drop. And you can see the effect this has because you all know there was a huge surge in border crossings, particularly of unaccompanied minors. And when did that happen? It happened when the DACA program was announced. The DACA program that provided basically an immigration amnesty for people who were minors when they came over here. And let me talk about the DACA program for just a second. You all should understand in the discussions about this, the president did the right thing in ending the program because he didn't have the authority to do it. The president the only power that a president has in the immigration area, because of the fact that the Constitution gives plenary power to Congress over this, is whatever power is delegated to him by Congress. And in the DAPA area, the Congress has never delegated to the president the ability to provide an amnesty to illegal aliens and to provide them access to government benefits. That's very clear. The other thing that you all should realize is that, one, providing amnesty is a very bad idea, because amnesties do what? They attract even more illegal aliens. The 1986 amnesty bill that Ronald Reagan signed, they originally believed it would provide amnesty for about 1 million illegal aliens. It ended up providing it for 3 million. And you know what happened in the 10 years after that? There was a huge surge in illegal aliens coming to the United States. Why? Because the feeling was, well, the government provided amnesty once. If we get to the U.S., maybe they'll do it again. So I can tell you, providing amnesty now, it was just a terrible idea. And you all should understand that the way the media is projecting this idea of the DACA recipients, right? Now, what do you constantly hear about? Oh, these are all people who came here when they were toddlers, 2 or 3 years old, and they don't speak the language of their home countries. The DACA program qualified people who came here when they were up to 15 years old. Now, I don't know, we have a few people in here who are not too far away from 15. The rest of us who are a little further away, I have 3 kids. By the time they were 15, they had what? 10 years of schooling. They spoke, wrote, and read English fluently, and they were completely inculcated in the American culture. So the idea that it would be some kind of terrible hardship to take someone who came from Mexico when they were 15, when they spoke Spanish fluently, had been grown up in the Spanish, in the Mexican culture, somehow that's some kind of hardship to send them back is absurd. The other thing is that you all should realize is the Center for Immigration Studies put out an article not too long ago. They estimated that at least 25% of the individuals qualified as DACA beneficiaries were functionally illiterate in English. Okay? And the other thing is, if Congress is going to do something about this, I don't think it's a good idea, but if they're going to do something about it, then they should make sure that, remember, what's the other thing that is constantly said in the media about this? These kids were not responsible for the illegal behavior, right? It was their parents. Okay, fine. If they're going to provide some kind of amnesty deal for them, then make sure you change the laws that we have about chain migration so that those individuals, which the majority of DACA recipients are now adults, by the way, make sure that if they are going to get some kind of amnesty, they can't sponsor their parents, the people who were responsible for the illegal behavior, so that the parents get the benefits of the illegal behavior. Those are the kind of things that can be talked about. Now, the other thing that the president has done, as you know, is try to go after sanctuary cities. Now, a lot of people don't understand what sanctuary cities means. Sanctuary cities basically have 2 policies in place. The first is a policy that says that local officials, particularly police officers, cannot provide any information to federal officials about an illegal alien who they arrest or detain. So, if the local police arrest someone for burglary or a rape or assault, the person's convicted, they're serving time in a local prison, the local sheriff cannot let the feds know that they have an illegal alien in prison there. And the second part of the policy is when it comes time to release that individual, the local sheriff will not hold that person for the feds to pick up. Now, what you all need to understand about this is that, first of all, there's a federal immigration statute that says it is illegal for local officials to ban other local officials from talking to the feds and exchanging information. Rudy Giuliani, when he was the mayor of New York and this law was passed, filed a lawsuit saying, oh, you can't tell us what to do on that. The federal court said, well, yes, we can. We're not commandeering your local officials. We're not saying they have to call the feds. We're simply saying you can't forbid them from calling the feds to let them know about it. The other thing about this is that you should understand is that what these sanctuary policies are doing is creating sanctuaries for criminals. And what these local officials are saying, local elected officials are saying, we would rather release a rapist or somebody who committed assault or a burglar. We'd rather release them back into the local community so they can victimize more people rather than calling the feds so they can come pick them up and deport them, which is a crazy idea. In 2005, the GAO, Government Accountability Office, did a study where they looked at the criminal histories of 55,000 illegal aliens. These were individuals who were illegal when they came into the country, were illegal when they committed their crimes, and were illegal when they were serving in prison. These 55,000 individuals had been arrested 460,000 times and had committed 700,000 criminal offenses. 12% of those, by the way, were for violent crimes, murder, robbery, assault, and sex-related crimes. So they weren't in jail for immigration crimes. The other thing about these sanctuary policies is they're providing illegal aliens with more rights than you as a citizen. And let me tell you an example, a quick example of what I mean, going back to what John said about speeding on the highway. Okay, I've been stopped by a state trooper, I'll admit it, on an interstate. Now, what does a trooper do when he stops you because you've been speeding? You give him your driver's license, he goes back to his car, he checks to make sure it's a valid license, but you know the other thing that he's doing? He's checking the NCIS system. The NCIS system is the National Crime Information System. This is maintained by the FBI. And the FBI has this database that has federal arrest warrants and state arrest warrants. So if you're stopped on the highway here in Los Angeles, but it turns out that the state of Virginia, where I live, has an arrest warrant for you, guess what that trooper's going to do? He's going to arrest you. And he's going to put you in jail so that Virginia authorities can come and get you. If there's a federal arrest warrant on you, perhaps you robbed a bank, which is a federal crime, he's going to arrest you and hold you for the feds to pick up. But the sanctuary policy cities are saying if there's a federal detainer warrant on you because you're an illegal alien, we are not going to hold you, we're not going to tell the feds we've got you, because somehow that is a violation of human rights. So the illegal alien is treated better than a regular citizen. I'll end very quickly, because I'm running out of time, with the travel order. Okay, the travel order is up for oral arguments before the Supreme Court on October 10th. And the claims about this are so absurd, and they've been bought by all these nutty federal judges. Okay, I mean, for example, you keep hearing the sentiment that it's an anti-Muslim order. Well, I hate to tell these judges this, but you know there are 50 countries in the world with a majority Muslim population, and this travel order only affects 6 of them. And what does a travel order do? It said that for 90 days we're going to suspend entry of individuals from 6 particular countries while we check to make sure that DHS has the kind of vetting procedures in place to make sure we don't allow terrorists into the country. And we're going to suspend for 120 days the entry of refugees for exactly the same reason. Now, what were the 6 countries that were chosen? Libya, Somalia, and Yemen, all of which were labeled by the Obama administration as countries of concern because of major terrorist activity, major terrorist cells, and basically broken down governments. Should I remind people this is the 5-year anniversary of our U.S. ambassador being killed in Libya? The other 3 countries were Iran, Syria, and Sudan, which are labeled by the Obama administration as state sponsors of terrorism. There's over 70 individuals from these countries who've been convicted of terrorist-related activities in the United States, and in May, before he left the FBI, James Comey was testifying before Congress. He was specifically asked about counterterrorism investigations. He said that the FBI currently has 2,000 counterterrorism investigations going on. 300 of them are of individuals who came here as refugees. So the idea, again, that there's something discriminatory about it is that wrong. And the other issue to keep in mind about this, and then I'll end with that, is that the one area where the president has a lot of power in the immigration area is where this president issued his travel order. Congress passed a provision that specifically says the president has the authority to suspend the entry of any aliens or class of aliens if he believes their entry would be detrimental to the interests of the United States. That is almost absolute power to keep people out of the country, and it's been interpreted that way in one Supreme Court case after another. So the idea that he doesn't have the ability to suspend temporarily the entry of individuals from 6 what are basically terrorist safe havens in Africa and the Middle East, again, is an absurd abuse of the judicial power. And I'm hopeful that when this gets argued before the U.S. Supreme Court, they'll rule in favor of the president. Thanks.
So I thought I would just pose a couple of questions, one sort of political and then one practical, anticipating, I think, a lot of objections from the other side, especially in the practical question. The political question is, I read, you guys might know better than me, that somewhere upwards of 60% of the American public don't want to deport dreamers. So to the extent that we're a regime based on consent, the consent of the governed is an important thing, that you can't disregard it lightly. So what to do with that dilemma, if it's a dilemma, if I'm right about the numbers. And then the practical question you hear all the time is, how are we going to deport so many people just practically? And my follow-up to that is, after so many years of de facto non-enforcement, would that not argue at least for a bit of sort of incrementalism on the reintroduction of enforcement? The rule of law has been lapped for so long on this issue. How do we get back to the right place?
I'll take a first shot at that. Let me take the last half of the story. It is really a red herring, and I hear this all the time for people saying, there's 11 to 12 illegals in this country. We don't have the federal resources to deport them all. But you don't need to do that. If you had the federal government actually enforcing federal immigration laws, and you had the help of the states, the vast majority of the people who are here illegally would self-deport. And let me tell you what I'm talking about. If the federal government actually started enforcing this one particular provision of federal immigration law, which it hasn't really done, which is the provision that says it is illegal for an employer to knowingly hire someone who is here illegally, if they started actually enforcing that, and there were a few very prominent cases that got a lot of publicity, then suddenly employers all over the country would quit hiring illegal aliens, and if they can't earn money, they're going to leave. The second largest source of income in Mexico are remittances from the United States. If you then get the states to help you, there are a lot of provisions that they actually can do. Arizona, for example, some years ago passed a law in which they made the E-Verify system mandatory for state employers, and they said that if an employer is grandfathered in if they use the E-Verify system, but if they then knowingly hire an illegal alien, they can be prosecuted, and guess what? They can lose their business license. Now, anybody in the business world knows that's like a death sentence for a business. The U.S. Chamber of Commerce sued, went all the way to the U.S. Supreme Court. The Obama administration took the side of the chamber saying, you can't do that. The U.S. Supreme Court said, oh yeah, the state can. Alabama passed a law that said that not only do illegal aliens not get driver's licenses, that can be somewhat effective, but you can drive for a long time without a license. They also said you can't get a license tag for your car unless you prove you are a U.S. citizen or here legally. You do things like that and make it extremely difficult for illegal aliens to live, transport themselves, and work, and huge numbers are going to self-deport.
And proof of that is we've got a tax system. 150 million, 200 million people pay taxes every April 15th. We don't have enough IRS officials to enforce the tax laws against all 150 million people. And yet, by and large, they're complied with. Because the month leading up to tax day, the IRS brings a couple of high-level prosecutions that scare the bejesus out of all the rest of us into voluntary compliance. So voluntary compliance with a couple of well-targeted enforcement actions actually does a pretty good job of working.
No, I agree. Enforcement against employers is the key, but there are only two groups who want to continue illegal immigration in the country, and that's Republicans and Democrats. Republicans want cheap and exploitable labor, and the Democrats want future voters. And I leave it to you to figure out who gets the best of the bargain there. But this idea, you remember when Romney mentioned self-deportation and everybody ridiculed it, but that's the real key to this. Start prosecuting employers. It's against the law to hire illegal immigrants. Prosecute employers. The idea of losing your business license is a really good idea. That'll stop employing illegal immigrants and send them home. I should say illegal aliens. That's the proper phrase I've just learned. And they'll have to go home. And that's the easiest way to do it. Now, the Dreamers is a somewhat more difficult case. They've gotten everybody's sympathy. But we can't let compassion or sympathy affect our decisions. That's the wrong way of looking at things. Now, Trump said they're going to have to go back to their home countries and reapply for admission. We might be able to do something. It's within the president's power to give them priority in returning to the country. I don't know. Something like that could be worked out to assuage people's consciousness if they have a compassionate conscience or something like that. But we can't give them amnesty. Amnesty is a bad idea. It'll lead to more calls for amnesty. And if we don't give amnesty, we'll be called a people with a lack of compassion, and so on and so forth. But this idea of self-deportation, it's not that easy, not that difficult to arrange. Just make employment difficult, and I think the idea of self-deportation is a good one, and that's the easiest way to do it.
Put a couple of major CEOs in jail, even just one night. That tends to catch their attention.
Yeah.
Look, let me take up the public opinion question, though. If Ryan's right about the latest polls that 60% support keeping the Dreamers here, I'd be surprised it's that low, in fact, given the level of propaganda on this question.
Yeah.
So one of the things that's going on here is the utter collusion between the media and both Republicans and Democrats to put a bit of propaganda narrative out there that is just false. If we would instead focus on the fellow that killed Kate Steinle in San Francisco, or the number of MI6, is it MI6?
13.
MI13 folks that came over at age 15. Yeah, MI6, sorry. If I've got any British friends in here, that was a bad... well, who knows what the NSA doing, what they're doing. Whether, but if we would start focusing on that, or the other recent study I thought Hans was going to cite from a moment ago when he cited the other one, one serious study has indicated that nearly 50% of the DACA recipients used fraudulent documentation to show that they had been brought here as children. Yeah. And if we start focusing on those things, that would start changing that propaganda narrative that is out there right now that has produced those poll numbers. But let me also say something about the legal issue about leave and return. When the DACA program was first implemented, I warned that this was one of the ulterior motives of the Obama administration. By using that phrase, lawful presence, there is a statutory prohibition on somebody who is here in this country illegally from being readmitted lawfully unless they have left and stayed away for 10 years. Right? And by saying that they were lawfully present, the leaving and then coming back means they are re-entering lawfully, and they are immediately on a path toward citizenship, contrary to the statute as it's written in Congress.
That's true.
And I raised this issue early on, and everybody said, "Oh, that's not happening. That's not happening. You're making it all up." And we now have evidence that over 180,000 people have taken advantage of this touchback return in violation of the explicit law, but in taking advantage of this manipulation of the law that the DACA program did.
Okay, I think we'll open the floor now for questions. Start down here.
Thank you so much for a wonderful program today. I just have to start off by saying that you talked a little bit about sanctuary cities. I'd like to talk a little bit about the fact that California is on the precipice of declaring itself a sanctuary state with the passage of SB 54, which I'm assuming, I should probably not assume, but probably it's a safe bet that Governor Brown will sign that. So it's setting, I guess, California up as being part of this grand showdown. I'd really like to hear what you guys think about that.
So the first litigation on that happened in Chicago this past week. Attorney General Sessions has tied funding for the Byrne Grant Program to local police departments to 3 conditions. One, you got to comply with the provision in federal law that you can't prohibit officers from giving information to immigration services. That condition was upheld. The other 2, that you have to, if you accept these grant monies, you have to give us access to your prisons to interview illegal aliens, and you have to notify us 48 hours before you release them so that we can pick them up if we want to. The court struck down those 2 provisions. It's a thoroughly reasoned opinion. So I'm not, I mean, it's very complicated and nuanced on where the statutory provisions occur. But the essence of the opinion is there was something unique about the lack of authority to impose conditions on the Byrne grant that doesn't exist with the Attorney General's authority to impose conditions on a whole lot of other grants. So if I were the Attorney General, I would take that decision. It's a loss for him in part, but the parts that are opened up to him, say, okay, not the Byrne grant, but how about the following 12 grants that you also get? And the state of California, how about the 38 grants that you get? And this court has now authorized us effectively to impose compliance with our requests as a condition on those grants, and you'll lose all that money. Now, California will sue, and it'll be brought in the Northern District of California in San Francisco, and the judge will issue a nationwide injunction without even citing the statutory authority. I have no doubt. But the question is, what will happen when that gets to the Supreme Court of the United States? And I think we will win those cases there.
Yeah. Oh, it was, okay. Yes, sir.
Mr. Vance Spakovsky suggested that if the Dreamers are legalized, at least eliminate chain migration so that their parents will not be directly rewarded for their law breaking. I don't think they should be legalized because, as Congressman Rohrabacher said, that tells every parent in the world, bring your child here, break your laws. We'll reward you at least to that extent. But assuming my member of Congress is probably going to vote to legalize them, I would like to tell my member of Congress, okay, if you're going to legalize the Dreamers, let them stay. I want you to vote, change the law such that their parents cannot be sponsored by them someday, and the parents get rewarded. Now, my question is, you just stated very briefly end chain migration, but I want to know if there's something I could point to, proposed legislation drawn up by Heritage Foundation or a member of Congress, or something I could point to and tell my member of Congress, okay, if you legalize them, the Dreamers, pass this particular thing with it. Something specific I could tell my member of Congress to vote for at the same time you vote to legalize the Dreamers. Is there anything existing like that I could point to right now?
Well, I will tell you the Heritage website, we have a number of papers and studies there that make recommendations on changes that ought to happen in our immigration policies so that we can get this under control. So that's available on our website. I should mention, this is something John is a real expert on, is, look, one of the other biggest problems we have, this attracts huge numbers of illegal aliens in who then take advantage of the system because of it, is something that we do that almost no other countries in the world do. Only about half a dozen actually do this, and that is the idea of birthright citizenship. The birthright citizenship is a misinterpretation of the 14th Amendment. The 14th Amendment does not require birthright citizenship, but that's what we do. And, you know, there's a whole cottage industry, for example, of agencies who work to bring women in who are pregnant just so they can have their child here and then use that as a way of being able to stay in the United States. And that's something that we really need to end.
By the way, one of the arguments the other side puts out, for example, if you don't allow chain migration, well, you're going to separate these kids from their parents. I've got a wonderful little analogy. We've got a little amusement park down the road here called Disneyland. And suppose you want to take your 8-year-old down to Disneyland, and you get over there and you realize, my God, they've raised the prices. It's now $80 to get in. And I don't have enough to buy.
It's like $100 now.
It's $100 now? I'm a little behind. It's $100 to get in, and I've only got $100. I can't buy 2 tickets. So I buy the ticket for my kid, and I let him in, and then I go around the corner and I climb over the fence. And they catch me. And I'm, waiting in line on the first ride with my 8-year-old, and they kick me out. Now, if I leave the 8-year-old there, who's separated the family, me or Disneyland?
Of course.
Yes, right there. Mike's right behind you.
I teach at Cal State Fullerton, the political science department, and we in Cal State Fullerton have at the Pollock Library there is a place where only DACA students can go, a really nice lounge. None of the other students are allowed to come there. And we were given a missive by the president of the university saying that we are going to stand behind our DACA students. So I'm sure a lot of you saw the way that Nancy Pelosi was treated by the DACA students the other day. I played it for my American government class, and I had them read the Wall Street Journal editorial talking about it, saying this is a lack of understanding of the way American government works, and I'm supposed to be teaching American government. And at the end, the last sentence was, it's too bad an IQ test is not part of a citizenship test to get in. Later that day, I got a text message or email from my chair, and in the title line, it said, "The atmosphere in your classroom." And she said, "We are going to protect our DACA students from now on." And she says, "Check your citizenship privilege."
You have tenure?
Pardon me?
You have tenure? I'm
They
sorry?
do not hire people like me into the political science department because of my point of view. I'm an adjunct.
I see.
Yep. Oh, but look, at some point we got a litigation center here at the Claremont Institute, and at some point, what some of these cities are doing and universities are doing is harboring illegal immigrants. They are harboring folks in violation of the law. They are, in fact, engaged in a wide-ranging conspiracy to violate federal law. And at some point, we've now got control of the Justice Department, at least we have it nominally. Why don't we start enforcing, because there's another provision in the immigration laws that makes it illegal to harbor illegal immigrants. And why don't we start enforcing those laws? And let's get the president of Cal State Fullerton in jail for a night and see whether he has the same view about harboring DACA recipients as he might have right now. I mean, it's time to start fighting back on this stuff, take our gloves off.
I actually have a suggestion on this. I want to point out, because you all know money is the real key to getting the other side. Let me tell you a provision of federal immigration law that has never been enforced by the U.S. Justice Department, and I hope to God that General Sessions has somebody advising him to tell him to start enforcing it. But part of the immigration reform in the 1980s Act was a provision that says that if a state provides in-state tuition to illegal aliens, they must also provide in-state tuition to any U.S. citizen. Now, that provision has never been enforced. There have been 1 or 2 lawsuits that were filed by parents of U.S. citizens who are upset that they're having to pay out-of-state tuition. And those cases, unfortunately, were dismissed because the court said that there was no private right of action. Only the U.S. Attorney General could enforce this provision. And the Justice Department has never filed it. I can guarantee you that if the Justice Department started suing states to provide in-state tuition, there's more than a dozen of them, and they were successful, the university, the states would immediately change their policies, because the loss to them of suddenly anybody anywhere in the country being able to come to their state schools without paying out-of-state tuition would be enormous.
We were about to bring a class action suit until the lack of standing case ahead of us was issued, and we calculated the value of the class action lawsuit was $3 billion, and we were only going to ask for a third of that in our attorney's fees. I think that would have put in big endowment for the Claremont Institute for a long time.
Well, we're out of time for today, but please join me in thanking all of our panelists. And John Eastman has some closing remarks, but right after that, if you're ready, willing, and able, we're going to go downstairs to the lobby for our reception. So thank you.
So thank you all for coming, and thanks Ryan and particularly the staff of the Claremont Institute, who I think have done a fabulous job in getting all this organized. I'd like your feedback. You know, this is a different kind of thing than normal political or even academic events. It's neither academic purely. I mean, it is on the normal panels, but it's not an academic audience per se. But I had sensed some years ago that there was just a hunger for this kind of conversation, because we're constantly confronted in our daily lives and in our Facebook pages and with family over Thanksgiving dinner and all of that with these propaganda arguments of the left. And I sensed a hunger for kind of having a discussion among ourselves that would help arm us to respond to those kinds of arguments. So, you know, I don't know if we have some mechanism for you all to give feedback, but if you think this is useful, let us know so that we'll keep doing it. I think it's important that as fellow citizens we educate ourselves as much as we can, not only about the fights of the day, but the deep underlying principles that ought to be informing how we address those fights. And that's what our aim is here. I hope we've accomplished it. And I won't say anything more because I know there's adult beverages waiting downstairs for us all. But thank you all for coming.